Good evening to all of you, and welcome back to our classroom, law of contracts after the strike by our lecturers. As you are aware, we will be writing our exams in a few days from now. So what we intend to do is to quickly mop up what we are supposed to have finished doing, but for the unfortunate intervention by the strike. Yes. So we would like to discuss discharge of contracts. Of course, by discharge of contract, we are referring to the various ways or means in which the parties are freed from their mutual rights and obligations under the contract. And the parties are discharged or free from their contractual obligations in four main ways. By performance, that is where the obligations have been performed as made, then they are released from further obligation, or by agreement, frustration, and breach. So we would like to tonight talk about discharge by performance. As far as frustration is concerned, I discussed it virtually during the strike, and I sent you the recording of that, and it's still available, so you are able to play that, and we will not discuss it substantively here again, except that when we finish all the aspects of this chart, I will conduct a one general seminar or tutorial here online, and some of the questions will be cross-cutting so that it will provide opportunity for us to still discuss maybe some aspect of frustration. So let's keep that in mind. So discharge by performance, what do we mean by that? We know that when a contract is made, it creates obligations or duties for the parties. Both sides, they all have one duty or the other to perform. Now, should they perform those duties, then that is a good thing, because as we know, pacta sunt servanda, isn't it? Agreements are meant to be binding and are meant to be obeyed and kept. You have sanctity of contract, so that is fine. But reality in the real world is that it's not all the time that you will get the parties performing their obligations under the contracts. You may get a situation where one side, one party has performed his obligation, and the other side has not performed his obligation. Now, the side or the party who has performed his side of the contracts could be said to have been discharged by performance. That is to say that he or she is released from further performance. Now, if one party, that is the party who has performed, has actually done what is expected of him under the contract, then we say that he is discharged. So he alone is discharged, meaning that he doesn't have any obligation under that contract. He's done what is required of him, so he's discharged. And by being discharged from further performance, he acquires the legal rights. That is the right of action against the other. Certainly, the other party would not have carried out his side. So the other party will be in a breach, right? So we see that there's a a very good correlation between performance and a breach. Because where you have two parties to the contract, one party performs so that he's discharged. The other party does not perform so that he is in breach. And then the one who performed, and then for that matter, discharged, acquires the legal right to be able to sue the one who is in breach. If that is how performance discharges a person, we would like to know what really amount to performance for purposes of saying that a party is discharged from the contract. The general rule at common law is that performance of the contract must be precise and exact. So that is what we call the precision rule, right? The precision rule or the exactitude principle. Precision rule or the exactitude principle. That is to say that you must carry out the contract strictly according to what was agreed. No more, no less. Maybe on this, those of you who have like appetite for literature, for the literary works, you remember William Shakespeare's work, right? Especially The Merchant of Venice. If you remember The Merchant of Venice, I like law and literature, so occasionally indulge myself in that. So if you look at The Merchant of Venice, for example, those of you who know like the story, the Shylock, right? Shylock and Antonio and all that, where there was a contract between the Shylock, like the Jew, and Antonio. And the contract was that if Antonio defaulted in repaying the loan, Oji has taken to enable his friend Bassanio to marry. What is happening is that, please, just a minute. Yeah, so coming back to the Sherlock and the Bassanio story, if you defaulted in paying, then a pound of flesh was to be taken from the body of Antonio. So that was the agreement. Now, of course, Antonio was not able to pay as agreed. So he was in breach. And Shylock had actually performed. So Shylock was not in breach, and he wanted to exact the punishment against Antonio. And of course, you see how the judge, Portia, who had disguised herself as the judge, for example, insisted that what Shylock was entitled to was just the pound of flesh, excluding blood. And for that matter, if you look at the contract, blood was not meant to have followed the pound of flesh. And so if Shylock was going to take his pound of flesh, he had to make sure that he did not actually allow any blood to drop. So that was like the precision rule, right? The precision rule, you're entitled to have a pound of flesh and not a pound of flesh and a drop of blood. So not until you have done that, you cannot say that you've actually carried out what the contract says you should do. I mean, that was just by the way. Now, coming back to our mainstream discussion, just to reiterate that the the general position of the law is that you cannot be said to have been discharged by performance unless and until you have carried out the contract precisely and exactly as was made. That is to say that you must have completely and precisely performed the exact thing that you agree to do under the contract. No more, no less. So just like the merchant of Venice example, Shylock, that you have to actually, yeah, some people say that my network is breaking, you know, those things, I cannot do anything about that. So just manage, but it's being recorded. Okay. Now, the precision rule or the exactitude rule finds expression in a very well-known case, a case of Carter and Powell. Carter and Powell, a 19th century case, involved an agreement between the plaintiff Carter to serve on a ship which was sailing from Jamaica to Liverpool. Another agreement, he was entitled to be paid 30 guineas on arrival at Liverpool. So the ship sailed on 2nd August and arrived in Liverpool on 9th October. But Carter died at sea on 20th September. Now, the widow of the sailor wanted to claim wages which the husband had earned before his untimely demise. But the court held that his widow could not recover anything for the work he had done before he died, because in the view of the court, construing the contract, Carter was obliged to complete the voyage, to complete the whole journey before he was entitled to any payment. So long as he had not done that, then he was not entitled to any payment, so to speak. So the case is Carter and Powell. And of course, that related to the precision rule as seen in the context of a service, right? The Carter and Powell was really about a service. But the same principle is also reflected in relation to OWUSU. So to take the case of Raymore and Co. and Landa against the Landa and Co., you notice that the buyer in that case had made an order for consignment of tin fruits, and the tin fruits was supposed to have been packaged in a certain way. That is, they were supposed to be packed in cases of 30 tins each. We put 30 tins in a box, so to speak. And the correct amount was delivered. That is, the full contractual amount or quantity was delivered. But it was discovered that half had been packed in a manner contrary to the agreed way of packing, that 30 tins should be in a box. And half were actually seen to be like 24 tins in a case or a box. But if you aggregate them, if you put everything together, you still get the total amount which had been agreed upon. Nevertheless, the court held that the buyer was entitled to reject the whole consignment. Now, when we come to contract for sale of goods, when goods are delivered and, for example, they don't meet the terms of the contract of sale, the buyer has the right to reject, right, refuse to accept delivery. So the court said that in this particular case, the buyer was entitled to reject the whole consignment because it did not meet precisely or exactly what had been agreed upon. What had been agreed upon was that you should put 30 tins in a box, and not any other way, right? Good. I hope you definitely see this precision rule to be quite harsh, or do you think that it's reasonable? And if you even put your mind back to the analogy I drew from William Shakespeare's work of Merchant of Venice, the Shylock and the Fan of Flesh, do you think that the precision rule of performance is a very good principle? Is it fair? If you want to speak, just put up your hand. Okay, so Bano Zipporah. Bano Zipporah.
Okay, so please, can you hear me?
Yes, please.
All right, so I think that it's actually fair because in a contract, and then as a result of the terms of the contract, you do agree on the various undertakings, as the various obligations that each and every party to the contract must perform a particular thing, and then you are to discharge that duty. You have to do it in a sense that it's accurate or precise. So anything which is done contrary to that would amount to a breach, because we know that a breach of contract arises where a party performs its part of a contract, but does not perform it as it was contemplated between, or as it has been stipulated by the terms of the contract also. So I think it's actually fair, yeah, in that sense.
All right. Okay, thank you, Zipporah. Let's take Samuel Nsowa-Boateng. Samuel.
Okay, so I also think these terms are very harsh because considering innominate terms in the sense of becoming a warranty, this, though there is a breach of contract, but it doesn't go deep, like it doesn't go into the root of the contract itself. So I think it should be considered as a warranty for the party in default to pay just damages to the innocent party than repudiating the contract itself.
Oh, right. Okay. Yeah, okay, all right. I get what you mean. Okay, so let's take Mavis Opoku.
Hello, sir.
Yeah, Mavis, please.
Yeah, I agree with what Nso was said. It is harsh. Sometimes, even though the party performed it defaultively, the party was wrong in the performance, or the party did not complete the performance, but then the other party, that's the innocent party, will benefit from the defaulting performance. So it's unfair for the innocent party not to pay anything or to be totally discharged from the under the contract.
Okay, thank you very much. I mean, yes, the viewpoint that you have expressed. Okay, let's take Anita there. Anita there.
Hello, sir.
Yes.
So I actually think it depends, because if the terms, for example, maybe the innocent party performed his side of the contract and the other party took advantage of the innocent party performing his side and decided not to perform his side of the contract, even though the innocent party had performed his side, it would be unfair to the innocent party if he's not allowed to repudiate the contract. But in the instance where maybe due to some unforeseen circumstances, the defaulting party couldn't perform the contract precisely as it had been stipulated, it would be actually unfair to that side, because it would be unfair to the defaulting party because it wasn't his intention not to perform the contract the way he did it or something like that.
All right. Okay. All right. Thank you. So thank you, Anita. So let's take Samson Seko. Oh, sorry, you lost Samson. Samson, put up your hand again so that I will release you. I think there was a mistake from my end. Okay, thank you. Samson. Please unmute yourself. Good. Yes, Samson, let's hear you.
Yeah, I also believe that it depends on the fact. It can be harsh, and it also can be a form of justice, depending on the facts of each particular case. Because in the Shakespeare case that you just referred to, I think it was harsh because you can never have a flesh without blood. So I think it was harsh. But in the other case where the man died along the voyage, he had carried out a portion of the contract. A portion of the contract before death, and death is a natural phenomenon which no one has control over. So the person should be paid the wages equivalent to whatever work that had been done before the person expired. That is from the 2nd to the 20th when he expired. He should have been paid that wages. And
okay, all right. Thank you very much.
That particular on the widow.
All right, thank you very much, Samson. Yeah, I'm very happy that some of you in your contribution, you were able to draw upon your knowledge of terms of contract. And I remember by hearing one of you saying that if the particular term which has been breached in terms of the performance not being exactly or precisely, then if it's, for example, if it's a warranty, then he thinks that where the innocent party to come under the precision rule and sort of reject whatever has been delivered, as we saw in Remo and Co and Landa and all that, that would be very harsh. But he was of the view that if what the defaulting party failed to meet in terms of not carrying out precisely and exactly as if it is in relation to a condition, then there's no problem. Then he thinks that the precision rule is fair. Yeah, so I mean, that's an interesting submission. Yeah, good. So in the light of the harshness which you've all seen, we will like to look at another illustration, and then we will then try and see how the common law has actually repositioned itself in order to mitigate the harshness associated with strict adherence to the precision rule of performance. Now, in the case of Bolton and Mahadeva, a very interesting case, Bolton and Mahadeva, where Bolton, had installed a heating system in Mahadeva's house for an agreed price of £560. The work was carried out effectively, and it was estimated that it will cost £179 to put matters right. It was held that since Bolton had not performed his side of the contract, he could recover nothing for the work that he had done. And of course, and this will also underscore the harshness which you have seen as far as the rule is concerned. And I'd like you to read the opinion of Lord Justice Cairns, right? Lord Justice Cairns. And if you read the opinion of Lord Justice Cairns, you will notice that he goes out of his way to review most of the other case law which are relevant to this area, including the case of Honin and Isaac, which we are going to be citing very soon, right? So Lord Justice Cairns in Bolton and Mahadeva, in portion of his judgment, which I quote, says as this, quote, "The action was funded on a lump sum contract, together with certain items of extras. The defense was that the plaintiff had wholly failed to perform the main contract, and the defense set out extensive particulars of defects in the work. It was admitted that a small sum was due for extras consisting of the preparation of a bathroom suit, that the defendant contended that the consideration for the main contract had wholly failed. Alternatively, he claimed to set off a sum counterclaim in respect of making good the defects. By his reply, the plaintiff considered that there were some small defects for which the defendant was entitled to a set-off, but otherwise he denied all the defendant's allegation. Then his lordship continued to review the principle. Quote, the rule, which was laid down many years ago in Carter and Powell in relation to lump sum contracts, was that unless the contracting party had performed the whole of his contract, he was not entitled to recover anything. That strong rule must now be read in the light of certain more recent cases, to which I shall briefly refer. Then he cited the case of, the first of those cases is Dickens and Lee, a decision of court for appeal in which it was held that where the amount of work which had not been carried out under a lump sum contract was a very minor in relation to the contract as a whole, the contractor was entitled to be paid the lump sum, subject to such deduction as might be proper in respect of the uncompleted work. It is necessary to observe that the head note of Dickens and Lee was based not on the judgments the court of appeal, but on the judgments that have been delivered in divisional court. Now, let me pass this comment. Look at what Lord Justice Keynes has observed, right, regarding a reported case, the case of Dickens and Lee. And he's saying that the law reporters, instead of reporting the decision from the court of appeal, rather reported the decision from the court below, from which the appeal had. And that is why we advise you not to settle for head note in law report, okay? The law reporters can also make mistakes, and they do make mistakes. So sometimes read the full judgment for yourself so that you get the correct version of the judgment. Now, ultimately, if you read Lord Justice Keynes, the point which he comes to is that it will depend very much on the nature of the defect. That if the defect is quite severe, then the defaulting parties should not be entitled to anything. But as you have rightly acknowledged in your contributions, that the precision rule of performance is quite harsh, and for that matter, some exceptions have been developed in order to circumvent strict application of the precision rule. So what are these exceptions? We will be looking at divisible or severable contracts, because so far, most of the contracts that we're talking about are lump sum, right? We'll be looking at if you have like a divisible contract, as whether the precision rule is still applicable. Then we also look at the situation of where only there's a partial performance or part performance, and the innocent party seems to have accepted that, or the situation where the other party has prevented you from performing your obligation, and also the situation of you having performed substantially. You perform almost everything required of you, less some minor defects and all that. So we'll be looking at these exceptions. So divisible contract, we have what we call entire contract, right? That is indivisible contract as opposed to divisible contract. When we say entire contract, that is to say that the obligations of the parties in the contract are interdependent, are concurrent, are, interrelated. They are very much dependent upon each other, such that neither party is entitled to demand performance from the other, either in whole or in part, until he himself has completely fulfilled or is ready and willing to fulfill his own obligation. In some contract, the obligation involves are such that one obligation cannot be considered independent of the other. So where that is the case, then the contract is an entire contract, it is indivisible. And for that matter, a party is not entitled to payment until he has completely performed his part of the contract, as it were. However, where a contract may be split, may be divided, right, or divisible, or split into several parts or stages, so that various parts or various aspects of obligation can stand on their own, independent of the other. Then, where you have performed those obligations which can stand independently from the rest of the contract, you should be entitled to payment for the parts or the stages which you have completed. So that way, we have an exception to the precision rule or the exact rule of performance, which requires that you must carry out exactly what the contract stipulated. Now, whether a contract can be severable, that is divisible, or not, depends very much on the intention of the parties. So in absence of evidence as to intention, the courts are reluctant to construe the contract so as to require complete performance before any payment becomes due. So if you look at the case of Roberts against Havelock, for example, the defendant ship was sailing from Cardiff to Alexandria with a cargo of iron. When it was damaged and forced to dock at Milford Haven to allow necessary repairs to be done. The plaintiff, a shipwright, was employed and undertook to put the ship into thorough repair. Before the work was completed, the plaintiff asked for payment in respect of that part, which he had carried out. But when payment was refused, he sued to recover the amount to which he maintained he was entitled at that stage. The court held that the plaintiff would succeed as there was no agreement to the effect that the plaintiff will make no demand for payment until all the reports were completed. So we see that when it comes to interpretation of contracts, there's a presumption, right? The courts tends to look at the obligations as being severable or as being divisible, except where the intention of the parties are so obvious that they intended the obligation to be interdependent and not severable. Otherwise, the courts will not hesitate to recognize divisible or severable contracts where the circumstances clearly suggest that. And as we have said, if the obligations are severable, then if you perform parts or if you perform like up to a certain stage, that should entitle you to payment. Another exception to the strict rule of performance is acceptance of partial or part performance. And it simply comes to this, that if one party to a contract partially performs the obligation and the other party accepts the benefit of the partial performance, then he is obliged to pay a reasonable price for it. What that means is that the one who has tendered the partial performance has not really done what is required. But since you have accepted it, right, you, the recipient of that partial performance, you have accepted it instead of exercising your right to reject it or something like that, then the law will not allow you to keep the benefit of it and refuse to make payment for that which you have enjoyed. However, if the circumstances are such that the party receiving the benefit for partial performance does not have the option of whether or not to reject the partial performance, then he is not obliged to pay for it. What this means is that before the acceptance of partial performance or part performance exception will be applicable, the circumstances must be such that the party who, Anita, you want to say something? Anita there? Okay, all right. Yeah, so where, excuse me, I mean, before the acceptance of partial performance will work as an exception to the precision rule, the circumstance should be such that the person accepting the partial performance must have had an option, must have had alternative as whether you will reject it or you accept it. But if the circumstances were such that he did not have any alternative and he had to necessarily accept it, then the fact that he has accepted the partial performance will not automatically entitle the person who tendered or who made the partial performance to get payment for it. So let's keep that in mind. And the case is the Sumter against Hedges. Sumter against Hedges. The plaintiff, who was a builder, contracted to build 2 houses and stables. 2 houses and stables upon the defendant's land for a sum of 565 pounds. The plaintiff did part of the work. The value of what he did came to 333 pounds. And then he abandoned the contract. And the plaintiff, the defendant had to complete the buildings and by himself. And the plaintiff claimed payment in respect of that part of the work which he had carried out. So what the defendant did was clearly partial performance or part performance. But will the defendant be, the plaintiff who has done the partial performance, will he be entitled to payment for what he had done? So if you look at the judgment, especially the opinion of Lord Justice Smith, right? If you look at Sumter and Hedges, Lord Justice Smith spoke, and part of his opinion, he spoke as follows, quote, when the buildings were still in an unfinished state, the plaintiff informed the defendant that he had no money and was not going on with the work anymore. The learned judge has found as a fact that he abandoned the contract. Under such circumstances, what is a building owner to do? He cannot keep the buildings on his land in an unfinished state forever. The law is that where there is a contract to do work for a lump sum, until the work is completed, the price of it cannot be recovered. Therefore, the plaintiff could not recover on the original contract. It is suggested, however, that the plaintiff was entitled to recover for the work he did on a quantum merit. But in order that that may be so, there must be evidence of a fresh contract to pay for the work already done. Then he cited like the authorities, and then he move on. And then you should also look at the decision of Collins, our Lord Justice Collins. Of course, the well-known Chitty, right? You know Chitty on contract, who was a court of appeal judge at the time, also sat on this particular case, Sumter and Hedges. But Chitty concurred in the judgment, and let's listen to portions of the decision of Lord Justice Collins in the same Sumter and Hedges. Lord Justice Collins speaking, and quote, "I think the case is really concluded by the finding of the learned judge to the effect that the plaintiff had abandoned the contract. If the plaintiff had merely broken his contract in some way so as not to give the defendant the right to treat him as having abandoned the contract, and the defendant had then proceeded to finish the work himself, the plaintiff might perhaps have been entitled to sue on quantum merit on the ground that the defendant had taken the benefits of the work. The defendant had taken the benefits of the work done. But that is not the present case. There are cases in which, though the plaintiff has abandoned performance of a contract, it is possible for him to raise the inference of a new contract to pay for the work done on quantum merit when the defendant having taken the benefit of that work. But in order that that may be done, the circumstances must be such as to give an option. And this is why I want you to pay attention. Lord Justice Collins speaking in Sumter and Hedges. But in order that that may be done, the circumstances must be such as to give an option to the defendant to take or not to take the benefit of the work done. It is only where the circumstances are such as to give that option that there is any evidence on which to ground the inference of a new contract. Whereas in the case of work done on land, the circumstances are such as to give the defendant no option. Whether he will take the benefit of the work or not, then one must look to other facts than the mere taking the benefit of the work in order to ground the inference of a new contract. In this case, I see no other facts. Okay, so I mean, just Lord Justice telling us about what we've been hammering, that before the exception can apply, it must be such that the other party, that is the innocent party, the defendant, had an option, and having an option whether to accept or reject the partial performance, chose to accept the partial performance. And then once you've done that, then if you've taken like the benefit of it, you must actually pay for that. But in the Sumter and Hedges case, if you look at it, the court's conclusion ultimately was that the plaintiff could not recover the money because though the defendant accepted the plaintiff's part performance, the defendant had no option to reject. And it was impossible to reject a half-built house since the status quo cannot be restored. Now, if you ask someone to build a house, it's only done part of it. And the law says that you can reject partial performance so that you don't have to pay anything at all and so on. Now, if you reject it, the uncompleted house is still on your land, isn't it? Does it mean you're going to pull it down and then start building from scratch and all that? So that is the wisdom in the Sumter and Hedges case. Another exception to the precision rule of performances, where there has been what do you call like the prevention of performance. If you prevented someone who's supposed to perform an obligation under the contract from performing what is required of him or her under the contract, then he can choose to bring an action for damages for breach of contract against you, or he can bring a quantum merit action to claim for the work done. So quantum merit simply means that as much as your performance is worth, right? Or in construction contract, you call it the pro rata, right? Pro rata. So in the interesting case of a plunge against a Coben, for example, the plaintiff agreed to write a book on custom, like actually like a periodical publication. And the name of it from the report was to be the Juvenile Library. So the contract was that the book which was being written will be serialized, right? In the form of like the periodicals have indicated. And the plaintiff was to be paid £100 on completion of the book. Now, after the plaintiff had done some research and written some of the book, but before he had completed it, the defendant stopped publishing the periodical. So you say that you're going to do series, right? You're going to do series, maybe it's just like setting up like a magazine or anything like that. And you've asked someone to be writing maybe something about fashion of modern youth. The person is going to be doing like the series of writing and that. And you say that you are no longer going to do the magazine. So if you're not going to do the magazine, what it means is that the drafts that he has done cannot be published, cannot be serialized as had been agreed. So the court held that the plaintiff had been wrongfully prevented from performing the contract. For him to be able to write the contribution for the magazine must be running. But here is the case, you have abandoned the publication of the magazine as it were. So you have prevented him from performing his obligation. And for that matter, the court was the view that for the work that he had done so far, before the other party prevented him from performing his obligation, he was entitled to payment on basis of quantum merit. That is, he was entitled to payment for what he had performed was actually worth. Another exception to the precision rule is what we call the doctrine of substantial performance. And the doctrine of substantial performance simply means that where a party has substantially, that is, nearly completely, right, perform his obligations under the contract. Perform his obligations under the contract, he's entitled to claim the contract price less a reduction for defects or deficiencies. Now, this type of exception is applicable where the defects you're complaining about is in relation to quality of performance. So let's suppose that, as we saw in the case of Onin and Isis, very interesting case, the defendant employed the plaintiff to decorate and furnish his flat, and at the total price of £750. The construction was done, the furnishing was done all right, but having completed, defects were seen in the furniture. And if you wanted to correct those defects, you needed to hire people and spend about £56, right? So the defendant argued that the plaintiff was entitled to reasonable remuneration and not the contract price. But the court disagreed with the argument of the defendant and maintained and held that having regard to the circumstances of this case, it's quite clear that the plaintiff had carried out virtually everything required of him or her under the contract. And for that matter, if there were some minor defects, that should not deprive him of the agreed contractual price. But in order to make good the minor defects, we needed to take the amount of money needed to correct the minor defects from the agreed contractual price. So since £56 was what was required to rectify the defects, that was going to be deducted from the contractual price of £750. So that is a substantial performance doctrine as an exception to the precision rule. But if you contrast Honin and Isaac with the Bolton and Mahadeva, which we have seen already, Bando, is Mimi in this class? Mimi, are you here? Mimi, if you are here, show off your hand. Yeah, I'll allow Bando.
Hello, please, Dr. Dapa.
Yes.
Please, can you also, like, does the case of Brazil Electronics also apply here?
Okay. Yeah. Brazil Electronics. I like the analogy that you are trying to do. Brazil Electronics, it was not, you see, Brazil Electronics, the reason why I get the connection, but I wouldn't treat it as being on the same pedestal with the, what do you call, like the case of like the Honin and Isaac that we have discussed. Because Brazil Electronics, we noticed that the swimming pool which had been constructed, right, did not meet exactly the agreed specification. But it was not the case that you needed to correct, you needed to correct defects in the quality of performance. But the court was prepared to award compensation in relation to the fact that the man wanted to build a swimming pool of a certain specification and not having obtained that he has lost a certain joy, the amenities, certain intrinsic pleasure. Yes, I contracted to have a swimming pool of this particular specification made. Not getting exactly that, I feel a sense of not being fulfilled, because that is not what I bargained for. So the court awarded damages for loss of amenity, but that was not really to make up for defects in the quality of performance. I think that is a distinction that can be drawn. I don't know if Bando, you have alternative submission.
Well, I thought it would apply because I think the plaintiff wanted the pool to be 7 feet, and then the contractor made it just 6 feet. But because the difference is a bit trivial, so, and the court also didn't allow him to recover all the damages of rebuilding the pool. So I thought maybe and I think I also remember one of the judges also mentioning substantial performance, but then I'm not sure. I think so. That's why I asked if it applies.
Okay, all right, good. But go back and read. I mean, it's relevant. It's relevant. As I said, the fact that it's not on all fours does not mean that it's relevant. As you rightly said, if you look at the speeches, yes, references were made to that. Yes. Okay, so very well. And let's look at the last exception. that is a term of performance. So at common law, where a person who failed to perform his obligation under the contract within a given time, like you are supposed to, carry out your obligation within a particular period of time. If you don't do that, yes, you are in a breach of contract. That if you don't meet the time of performance, the deadline for performance. But if we look at equity, as we know from maxims of equity, that that time is only of the essence if the parties expressly state, or if a party who has been guilty of undue delay is notified by the other party that unless he perform his obligation within a reasonable time, the contract will be regarded as breach or broken. So in terms of time, with respect to performance, breach, and all that, it will depend very much on what the parties agreed upon. If from the circumstances of the contract, time was really crucial, then certainly if you are not able to meet the agreed time, you'll be said to be in a breach of a contract, as it were, and that cannot be an exception to the precision rule. So let's take note of that. Now there's a case which I would like you to read. Very interesting case with respect to time. I think my sharing is misbehaving. So the case of Charles Richards Limited against the OPNM. Charles Richard, let me see if I'm able to get it shown for you. Good, yeah, so Charles Richards Limited against the OPNM. As early as 1947, the defendant ordered from the plaintiffs a Rolls-Royce chassis, and then in July, the plaintiffs agreed that a body should be built for it within 6 or at most 7 months. So within 6 or at most 7 months. The body was not completed 7 months later, but the defendant agreed to wait another 3 months. And at the end of this extended period, the body was still not built. The defendant then gave a final notice that if the work were not finished within a further period of 4 weeks, he will cancel the order. The body was not finished within this period, and then the defendant canceled the order. And then the complete that body was delivered or tendered to the defendant 3 months later, but he refused to accept it. And eventually, when the matter came before the court was of the view that the defendant could not have refused delivery merely because the original date had not been met, but he could do so upon giving the plaintiff a reasonable time to deliver. And here, the notice did giving a reasonable time, so the defendant was justified in refusing delivery. Yeah, so I think these are the few points that we need to remember as far as discharge by performance is concerned. So as I told you, we've already done the discharge by frustration. So go back and play back your lecture on that. Tomorrow, we'll discuss, we've also discussed discharge by breach when we're discussing remedies for breach of contract, but we touch on it briefly in addition to discharge by agreement, and effectively that should mark the end of discussion of the topics. And then I will give you a couple of questions and we discuss together on this platform. All right. So if there are any questions, I'll just take I have 3 more minutes. Then I need to rush to the garage to pick my car before they will close. Okay, so thank you very much. And then we will have the class tomorrow.